Another look at some of the body cam video of the deadly shooting of Daunte Wright by a former police officer in April of this year. Opening statements began today in the trial of Kim Potter. She's facing first and second-degree manslaughter charges after mistaking her gun for what she thought was her taser. Prosecutors argue Potter, who had a long history in law enforcement, should be held criminally liable for the 20-year-old's death.
She was the 26-year veteran. She was the officer in charge. And it was her job to show Officer Lucky how it's done. And what did she show him? She showed him how to kill someone.
The language was direct, it was clear, it was unmistakable. And all Mr. Wright had to do was stop. He was told he was arrested on a warrant. He resisted. She said, "I'll tase you." And all he had to do was surrender.
Joining us now for this and I guess more about the other trial that we're all following as well, that one, the Jussie Smollett trial here in Chicago, our criminal defense attorney Trent Copeland and criminal psychologist and columnist for Front Page Detectives, Dr. Carole Lieberman. Trent, let's start with you. First and second degree manslaughter charges here. What's the difference and how does it come into play in this case?
Well, you know, they're different, and the variations, Joe, are not terribly substantial. But with respect to first-degree manslaughter, it is if you engage in criminally reckless behavior, conduct that is so beyond the pale, conduct that is both reckless and criminally negligent, that it would cause a reasonable person to believe that you're engaging in conduct that is more likely to produce violent, dangerous problems. Violent or dangerous consequences. And that's really what the distinction is from second-degree manslaughter, which is a slightly less standard. It is you're not engaging in reckless conduct, but you are engaging in conduct that is likely to lead to the death of someone. In this case, it was Daunte Wright.
Carole, you wrote that you don't think he can get a fair trial in Minnesota. Why is that?
Absolutely. This is in the shadow of the George Floyd trial. I think that they should have tried to get a change of venue. Certainly there should have been the jury sequestered. We should have learned that from the George Floyd trial. There is so much influence, there is so much intimidation by people, the same people who were intimidating the same crowds outside the George Floyd courthouse. And, you know, and in this case, they have already intimidated some of the people involved, the people who were, you know, there was someone who quit because, or resigned from this case because the protesters came to his house and so on. There were a number of people who they already intimidated. So I don't think that she I think, you know, this is as a forensic psychiatrist and expert witness, I have been doing this for over 20 years, and I have seen this change just recently, where the mobs, the people who are trying to intimidate the jurors, you know, we saw it obviously in George Floyd, we saw it in Kyle Rittenhouse, and now we're seeing it here. And we can't have a justice system where juries are going to make decisions based upon fear of based upon being intimidated and fear of what's going to happen to them.
This was a concern, Trent, I guess, in Rittenhouse and also in the Ahmaud Arbery. These were both in small towns, right? But in the end, I think everyone felt like we got the verdict that we maybe not expected, but was proper and should be respected.
All right. I think that's right, and I'm going to disagree with my old friend Dr. Lieberman, who I've used in cases before, and she certainly knows her stuff. But Carole, you're dead wrong here. Either the Ahmaud Arbery case or whether it was in the Rittenhouse case, those jurors, I don't believe, were intimidated by what was happening outside of the courtroom. I think they followed the evidence that took place in the courtroom. And there's been no evidence here that in this case, in Kim Potter's trial, that there is going to be a substantial likelihood that these jurors are going to engage in jury nullification, not look at the evidence. It's clear. Look, and the reality is that most of these jurors are white jurors. These are jurors who come from the community. Our justice system has to work this way. It is designed so that people get a fair trial of people who are in their community, of people who are like them and around them. That is what our justice system is built on. It's a justice system where you receive a trial based on who your peers are. And we don't take these cases out of one county or out of one state to go to another state, particularly when we know that this is a case that is receiving national attention. It's not as if this case is going to receive any less attention in Minneapolis than it is in Missouri, because these cases are happening all over the world. They're happening all over this country.
No, I beg to differ with you. The kind of emotion that was created for the George Floyd case in Minneapolis, that is something that is really more than we have seen and really has continued. I mean, it wasn't that long ago. And
Carole, are you suggesting that the emotion of the crowd...
Wait a minute. Yes, certainly we were, for Kyle Rittenhouse, I think that the jury did make the right decision. I didn't mean to imply that they didn't, but it was amazing that they did, because in the courthouse, while they were deliberating, they were hearing the chants from the outside, "No justice, no peace." Now, the Ahmaud Arbery case, I do think there was a problem with that. But, you know, one of the things is the media really hasn't been covering the other side of this, which is, well, first of all, the prosecutor and the defense agree on the fact that it was an accident. I mean, agree that she meant to take the taser. Right. So that isn't an issue. But you know, one thing that I haven't really seen come out, and that, you know, is a little one-sided, is that Daunte Wright, when he had a warrant and so on, there's a case. You know, there is a woman. He stayed over at a woman's house, and then in the morning he tried to strangle her to take her money. And there's another case where he's accused.
Carole, let me interrupt here. I've got to jump in here, Carole. You look, that's irrelevant. It's not a part of this evidence.
Well,
it had nothing
really.
to do with what took place. No, Carole, you're doing exactly what the defense would like to do, and that is to put the victim on trial. What he did outside of the issues and the date and the time that when this took place has nothing to do. And what you're suggesting, Carole, is that he's a bad guy. What you're suggesting. Let me finish. What you're suggesting, Carole, is that somehow because he was either
Can I get a word in here,
Carole,
please?
let me finish a moment.
Hang on, let him finish, Doctor.
You went on for a while. I gave you some time. Let me just jump in, Carole. Carole, you're going all over the place here. This has nothing to do.
No, wait a second. Wait a minute. I really want to get a word in here. This is ridiculous. They put on Dante's mother
Trent,
as
let her go for a second. Go ahead, Doctor. Make your point.
Thank you. They put on Daunte Wright's mother as the first witness. And of course, you know, that's a very emotional, I mean, she lost her son. It was of course it's sad and all of that. But, you know, the way they are portraying Kim Potter is totally one-sided, and you do need to know. I mean, you know why it's important to know about Daunte Wright's past history, his past issues, his violence past? It's because
no, I don't.
When you
I don't
try
know
to
why
judge,
it's important, because it's not important.
Okay, well, if you'd be quiet, I would finish, because this contributes to why it was the whole moment when she took out what she thought was her taser, when he was getting back into the car, and she thought that he was going to drive away and her police colleague was going to be killed. It's important to know the mindset of Daunte Wright.
Okay,
so
Doctor, let me pick it up from there. Hang on, Doctor. Let me ask.
That explains his mindset.
Let me ask Trent a question to what I think you're bringing up here. First of all, Trent, is what happened and why the warrant was out there relevant in this case, number one, and number two, to Potter's defense attorney's point, all he had to do was stop and not try to get away. Is that relevant in the case?
No, look, Joe, let me address the last point first. The whole idea of, you know, all he had to do was comply, all he had to do was stop, and none of this would have happened. Well, I suppose that has some bearing in reality, but he didn't comply and he didn't stop. And what police officers have to do is to take into account the human frailties. He was afraid, but what these officers didn't think was that he was violent. What these officers didn't believe was that he possessed a weapon. What these officers didn't know was that he had a violent past, because he didn't have a violent past.
Well, he had the outstanding warrant,
Trent.
What was the outstanding warrant for?
He had an outstanding warrant, but that doesn't mean, Joe, that he presents an immediate danger or threat to these officers. Whether he had people have outstanding warrants for a variety of reasons all the time.
Was it for a gun violation, Trent?
But It was for a gun violation, but there was no
That's
evidence
why
that he had a
she
gun
was
in the
af-
car, Joe. There was no evidence, Carol,
But
that he
that's
had
why
a
she
gun
was
in the car,
afraid.
that he was intending
She
to
was
use one.
afraid that
In
he
fact,
would.
the officer, in
come
fact,
on.
Officer Lucky testified that he had been compliant, that he was cooperative, and up until the moment where he tried to put handcuffs on him was when he tried to run away. And look, the reality is we cannot put defendants on trial for things that took place outside of what's happening under the strict circumstances where they're arrested.
Right.
And by the way, Carol, whether or not whether or not Kim Potter knew that he had a warrant for his arrest may be material.
Right.
It may be, but I don't think it's substantially material.
All right.
But the fact is, she didn't know anything else about him, and that is what matters.
Well, listen,
Her state of mind is what's
we're out of
important,
time, both
not
of you,
Dante's.
but this has been a fascinating conversation, and I think a preview of what we can expect in the jury room at some point. Attorney Trent Copeland and forensic psychiatrist Dr. Carole Lieberman, thank you both for your time.